Body of law are waivers, informed consent agreements, agreements to participate, indemnification agreements. Did we go through some of them, I think, already? Did we get through the waivers part and everything? We didn't go through it? All right, so a waiver is a signed contract between an organizing entity and participant. What does the waiver do? What does the participant is giving up when he or she signs the waiver? Right to sue. Right to sue, but that comes with some constraints, right? You cannot just say, okay, you sign a waiver to participate in my activity, and then I'm scot-free for anything and everything that may happen to you during you participating in this activity. There are some parameters and well-established guidelines that a waiver will only be good to protect you, the organizer of the activity, against simple negligence, mere negligence. Does that make any sense? So the participant is giving up the right to sue for simple negligence. Does that make any sense? So it's the only thing that you're going to be protected against. Anything else beyond there, beyond that, rather, still, open for you to be sued. Like gross negligence, battery, assault, any of those things, they're still, more than able to sue you for that. All right. So the other ones were the informed consent agreements, the agreements to participate, and the indemnification agreements. We'll talk a little bit more about it. The next conversation, the next chapter is actually about waivers. But just kind of have to give you a heads up. The informed consent agreement is, what it sounds like is when you, the activity organizer, pretty much lays out everything that has to do with the agreement, the inherent risks, and everything else that goes into it. And then the person kind of have the knowledge and the information they require before they actually decide to participate in that, activity. Agreement to participate is the same thing. Once you have laid out all the potential risks and hazards and, inherent to the activity, what could happen to them, they also kind of agree to participate. This one is not really a waiver, so they are not really waiving any right to sue or anything like that. They're just being informed of the potential risks. And then the indemnification agreements is that when something happens to a participant in your premises during your activity, then you just kind of settle. You kind of give them a some amount of money to kind of do, what do you call it? You indemnify those people for the wrong so that they don't sue you. Does that make any sense? They get injured. You kind of it's kind of a way of settlement. It's kind of a form of settlement. Right. All right. So then the next body of law in which you could frame a defense against negligence is a statutory law. Statutory law have two main branches to it. The first one is comparative fault, and the second one is contributory negligence. Earlier on, we kind of talked a little bit about this too, but what do you think they mean? So you are trying to frame a defense on this body of law, the statutory law, and then you have as your disposal either comparative fault or contributory negligence.
Comparative fault is something that was more like an accident, something that happened, not necessarily like, it can be a complete accident, sometimes it can be more calculated, but it's almost an accident. Contributory negligence is when you actually calculated it, you planned what you were going to do, and then you acted out on that plan. You were negligent in what you did.
All right. Tell me again about the comparative fault.
I'm not 100% sure, but it's more like an accident, something that could be prevented, but there wasn't a party that planned out an action, like I'm going to go do this, I'm going to go hit this person or whatever, and I'm going to go carry it out. They they're walking down the street and they accidentally hit them with their car.
All right.
I mean, I don't completely know how to explain it, but it's more like an accident compared to a planned action that you carried out.
All right. Anybody wants to add to that or kind of expand, or you think you have a different definition of what it means, comparative fault? All right, before we actually go into comparative fault, the defenses based on statutory law has two other tools, if you will, that you can utilize. The third one is immunity. And then the fourth one is the statute of limitations. All right, so now we go and see comparative fault. Comparative fault has two forms to it. One is seen as the pure form of comparative fault. And it pretty much says that the award to the plaintiff is reduced by the percentage of fault assigned to the plaintiff. So this is a notion that says that sometimes the court system, the judicial system is going to look at a case and actually look at how much of the fault of whatever the incident was can be placed on the plaintiff, right? How much they were at fault for the incident to have happened, right? And so usually this comparative fault thing is like, okay, they say the plaintiff had about 30% fault in the, was at fault of the accident happening or the incident happening. So if they were seeking 10,000 in damages, then they'll take away 30% of that, and then they'll recover only 7,000. And then the modified version of it is that you're still looking at the amount of fault that the plaintiff had in the incident happening, and if it gets to a certain point, and it's usually if the court finds that the plaintiff was at fault about 51% of it, then they wouldn't recover anything at all. Right? So pretty much they were at fault more than half of 100%. Does that make sense, the comparative fault? All right, it's just kind of placing the degrees of fault between the plaintiff and the defendant, and then the pure form says we're just pretty much going to deduct the percentage of the fault we think you had in this incident happening. The other one looks at, okay, if you were at least 51% at fault, then you just don't recover anything at all. So way to define it is that it's a system where percentage of responsibility of the plaintiff and percentage of responsibility of the defendant that contributed to harm, are taken into account when awarding damages. So this pretty much do the allocation of damages in proportion to what the court thinks, how much fault the plaintiff had. So that's comparative fault. What about contributory negligence? Contributory negligence. You are, go ahead. This is your time. No? All right then. All right, so contributory negligence. The plaintiff is responsible in part for his or her injury. The person acted unreasonably in avoiding risks. So if you think it's kind of similar to that comparative fault, but here we're actually coming to the plaintiff and saying, hey, you actually contributed to your injuries, right? And it's the same notion. If the plaintiff contributed to his or her injuries more than 50%, then there is no case. Right? If they were reckless, if they were pretty much the ones that did because of something that they did, that the incident happened, then they don't really have a case, right? And the notion here is that we already talked about that negligence has those four elements, and one of them, the second one is breach of duty. So the plaintiff is the one that is contributing to their own injury by being reckless or by not paying attention to instructions or not following instruction, etc., then they are found to have contributed to their own injury. You cannot claim or you cannot cry wolf when you are the one responsible for your own safety and you didn't take it seriously, right? And that happens sometimes, when you, as the organizer or the person running the activity, goes through the whole process of explaining to your participants this is what you're supposed to do, make sure that you follow instructions, tying in that seat belt or hang on to the rails, whatever it is that you are instructing them. And then during the activity, there's people that want to be cool, whatever reason they have, and they just pretty much do the total opposite. Then they, get injured, and then of course they want you to pay for it, right? So that's why we have the contributory negligence solution, right? You were instructed, you were being protected, but what you did pretty much wiped that out. Does that make any sense? This part of it as well? Does it? All right. Then we have the third tool that we have under statutory law to mount a defense against negligence. This one is sovereign immunity. The essence of sovereign immunity or governmental immunity is that the public agencies can be sued only if they are given consent by the government itself. Right? So this is that notion that the peasant cannot sue the king. It's the notion, and it's pretty much what it says, right? The government cannot be sued again unless it gives you permission to do so, right? It does not protect for things like wanton and willful or reckless behavior. So it's again only for negligence, and it only protects government entities. It does not protect government offices, agents, or employees. Sovereign immunity. Everybody got their notes on that one? It does not protect, it only protects government entities, and it doesn't protect government offices, agents, or employees. Alright, so again, sovereign immunity, the notion that the government cannot be sued against the government grants permission to be sued. Right? And then we have that second notion here, what it doesn't protect, and then I already explained to you what are the things of it. Alright? Everybody good on that one? Questions, comments about that one? Anybody has stories about how sovereign immunity has worked in the past? Alright. Then we have the recreational user immunity. This is, we just saw sovereign immunity. Every time you see sovereign immunity, it's the government. Then we have also another type of immunity which is bestowed on recreational users. Here we're not talking about like the person doing the activity that gets the immunity. It's the person that actually owns the land and then allows that land to be used as a recreational area for the community at large, right? So the characteristics is that the person that is going to get the immunity are the owners of the land. They're private landowners. That land has to be largely underdeveloped and pretty much rural in nature, like has some hills, mountains, some trees, some vegetation, all of that type of stuff, right? The landowner must refrain from willful and wanton, so it's kind of like that notion that we're just talking about simple negligence. The landowner cannot do anything that is beyond that simple negligence notion, because then they will be stepping into different types of liabilities, right? so they cannot do anything like beyond, yes,
Is this still based on statutory law?
yes. Because it's part of immunity.
Okay.
So the first part of immunity that we saw was sovereign immunity that protects the government from being sued. Now we're seeing that with recreational users that protects people that owns land and allows that land to be used for recreational purposes for the community at large, right? And we're just looking at the characteristics that have to be present in order for a landowner to be able to claim immunity under this law, right? So they have to be private owners, that land shouldn't be developed, and then the owner has to refrain from, reckless misconduct, willful or wanton, and any of those behaviors that may lead to the injury of the people that are using the land, right? So the landowner cannot be charged, the landowner cannot charge a fee for the person to use the land to either ride their bikes or jog or whatever it is that they're doing in the land, right? So they have to kind of open it to the public for free, right? For them to be able to use this immunity thing. They also have to make sure that they warn of any concealed dangers that are not obvious to the participants. Does that make any sense? Or that they may not be apparent, or they might not be easy to spot, right? So if you have a land and you have a lot of wiggly roads, and then you know that there is this one spot that kind of dips or has some, tree branches that have fallen up from, long time ago and you haven't removed it. You have to let those people know, right? Hey, about half a mile into the woods, you're gonna come to, this dip or this creek or this hole or whatever it is, right? Or, there's some bears that, hang around like about a mile and a half into the wood. Something like that. Anything that you know that may be dangerous, you kind of have to let it know or post it, at the entrance of the property, something like that. So it's like what, wouldn't be obvious to them, but the dangers, you have to let them know, right? For them to be careful, right? You don't really have the duty to go and make it pretty for them or remove them from them or anything like that. You have to let them know that there is a danger, right? Danger. And so if all of those characteristics are present, something happened to one of those people utilizing your land that you, out of the goodness of your heart, you open for the community, well, one of these people cannot really come after you, right? You have this recreational user immunity. And why do we think this one exists? What do you think is the purpose of this one? Why do we want to place immunity on a private landowner like this, with these characteristics?
Like if they're not making money, still want to be able to do these things, like protect for that
Okay,
activity.
all right. Anybody want to add to that comment? Or have a different answer? Yes.
Like people who want to hunt on private lands in case they get hurt.
Say that again a little bit louder.
Is it people who want to like hunt on private lands? So like if they get hurt, they can't go back.
And sue, right? But we're protecting the landowner, right? Why are we protecting the landowner in this case? We're protecting the landowner as an encouragement for them to open this land for the community, right? I mean, we have like a big city or any city, right, that has, somebody who owns all this land and they haven't developed it, and then, the government do want to encourage those people to open it for the people, like I was just mentioning, it might be a good spot for people to ride their bikes or go for a run or whatnot, right? So they do want to encourage them to, because that person could easily just enclose their property and pretty much, not let anybody in. But if they know that they have these protections for under the law, they're probably more willing to, okay, while I'm thinking about what to do with this land, I'm gonna let the community enjoy it.
Isn't the Manitou Springs incline privately owned? Because I was wondering if this would apply since it does have like those steps, it's somewhat developed, but I remember reading somewhere that it was private and I thought that was interesting, but.
And they don't charge at all? They don't charge you at all?
No.
In any other places?
I mean, for parking, but you don't have to pay to enter.
And the parking is, who's benefiting from that parking fee?
Yeah, I don't think it's the same.
You don't think it's the same? They may be very much, protected under this immunity, that, they're just allowing the community at large to utilize it, to enjoy it, when they could have just closed it. And if they are not profiting from it, and they are kind of posting at least of a minimum, guidelines of security or safety, they should be protected by this doctrine, by this law. All right. Volunteer immunity. We kind of also talked a little bit about this the first time we met. Also, it helps to encourage volunteerism. The volunteer, the Good Samaritan, remember we talked about that? Or the volunteer is protected from ordinary negligence. Actually, this is kind of to put together some of the biggest events that we have, especially in sports, but there are other industries that also rely heavily on volunteers. But since we're in the sport industry, we're going to focus on the sport industry. Like when you put together things like the Olympics, the Pan American Games, the World Cups, or your Copa America, whatever it is that you are putting together, you are going to rely heavily in volunteers to help you with the event, right? Large-scale events do pay a lot of people to work for them, but they also do rely a lot on people volunteering their time, right? So we have this immunity for them that protects them from ordinary negligence, simple negligence, right? It was an act that was passed in 1997 rather, the Volunteer Protection Act. It extends protection for volunteers in all states, not specifically covered under state statutes. Some states actually kind of go a little bit farther with the federal act, just to kind of put other protections, right? Like kind of extend protections. And we're going to see that with the Good Samaritan law, where Colorado actually goes a step farther than what the federal protection does, right? Does not bar from willful, wanton, reckless misconduct. And as you have already kind of seen the pattern, most of these defenses are for negligence. That's how we started the conversation, right? So in no way, shape, or form, they're actually going to protect an individual from anything beyond that degree of offense, if you will. Does that make any sense? So if you kind of step a little bit farther, then all these protections don't really cover you anymore. A different type of defense needs to be amounted for you in that case. If you actually do any of these sort of things, you cannot be covered under volunteer immunity. You and your counsel are going to have to come up with a different way to defend you, right? And then they also, the act has to be within the scope of the duties. So if they kind of commit an act of negligence, for them to be protected under the volunteer immunity defense, that act would have to take place while they were volunteering for the event. Does that make any sense? It doesn't protect them when they kind of finish their shift and then go home and do something different. Right? Questions, comments about volunteer immunity? This one is still under the statutory law body of law, right? So this is still a defense under that. I was telling you that some states have different versions of their own volunteer immunity, if you will, and one of them is like the Good Samaritan statute. Well, this one is actually at the federal level. It's legislatively imposed to provide liability protection for people that come to the aid of somebody who is in injury or in distress, right? I kind of told you the story about the person that got sued after saving somebody's life. Remember that? They were performing CPR and then saved the person's life, but while doing so, that person got a rib fracture or something like that, and then when they got out of the hospital, they went ahead and sued the Good Samaritan for help, right? So it's because of cases like that that we have these statutes to protect people that come to the aid of somebody who's in trouble, you know, injured, in need of help.
I was thinking of The Incredibles.
Yeah. Yeah. And does anybody has like any knowledge or stories about this happening? Not somebody getting sued, but somebody actually coming to the aid of somebody who is in need of that help, especially in the sport context or otherwise. It doesn't have to be particular in sport.
J.J. Watt, the hurricane movie from Texas, after what was it, Irma?
Right.
The hurricane. I'm sure it used to be raised like 4 million, 2 million, something like that now. That he's raised since the hurricane, but it was like 400,000 within a month.
Okay.
Hurricane relief.
All right. Yeah. So
It's
that's
not really necessarily like the situation, but he helped out.
yeah. Yeah. No.
Which I
Yeah.
think
That's yeah.
obviously that's above a good Samaritan, honestly.
Yeah. I had this one time we were playing tennis and we were like this court and then there were like 3 courts and then the 4th one there were these gentlemen playing and one of them I suppose was having a heart attack, you know. So the people next to they kind of went and started CPR until everybody was calling 911. So they kept doing CPR on this gentleman while the ambulance. So I suppose that in that case, you know, I don't know how it ended. I hope that the guy is okay because the ambulance came and took him and all that. Right? But it's kind of at that case, right? I mean, the guy he was right there. He went and helped. You know, I don't know what happened with the guy, but you know, this kind of a law kind of will protect him. You know, like nobody can claim, hey, it was something that you did that you know. If the guy didn't make it. Here we have the Colorado Good Samaritan laws that kind of extend a little bit more protection, provide some immunity from liability claims against medical professionals who have no obligation to help someone in an emergency situation. We already talked a little bit about how in some cases when we talk about the reasonable prudent persons, the courts might actually kind of extend that duty that they put over somebody if they have medical training, right? They expect you to perform the same way out there in the golf course or in the tennis court as you would with all your equipment at the hospital, right? So it's kind of a saying this, yeah, maybe he had the knowledge and all of that, but maybe he didn't have the right equipment or there's pretty much not much that one could do about that person. Yes, he's a medical trained physician or nurse or whatever, but the truth of the matter is that this person's health was already beyond any help by anybody with any knowledge, pretty much. Does that make any sense? So not make it like, oh, because you were a doctor, because you were a nurse, and that person didn't make it, and you know, it was something that you absolutely did wrong. And again, because they were trained, then some courts might want to put more pressure, more kind of a standard when they do that reasonable prudent person test, right? Yes, Amy, I saw you were.
Oh, my first car was a used car and it had, the person who owned it was a paramedic. So I had like a paramedic decal on it. And I just remember this one of my friends was like, oh my gosh, you're going to get in trouble if you pass an accident and don't stop. And I was like, what? Like, I never looked into it, but I just remembered it. And like, I can't remember where this friend was from, but they were like, yeah, people have decals have to stop, like, for law. And I was like, what? It sounds like this says you don't.
Yeah,
Like,
yeah.
at least here.
Yeah, I think that it's not like mandated by law that you have to stop as far as I know. This is more like if you actually do stop, right, and help, then, you know, when they do that reasonably prudent person, the burden that they put on you cannot be excessive just because you had that training. That's what this is trying to say. I don't know if it is more of because you take an oath to help, and I don't know if they were meaning like you had to stop because you had that moral and kind of an obligation, you know. But I don't know if it is a law that says, okay, if you have this training, it doesn't matter. It doesn't matter if it's a Sunday and you know you have to stop and help. You know, I honestly don't want to tell you one way or the other because I don't want to give you the wrong information. I will
It might
look
be
it up.
another state thing
I will
too,
I will
I'm
look it
curious.
up.
Okay.
I don't think there's really a law that says you must stop just because you know this, right?
I can't imagine there is, but it's stuck with me.
Yeah, I mean, you know, I would say that it's more that, you know, you took an off and you were supposed to stop and help. And I would say that I do know a lot of people in the medical profession, a lot of nurses, that they usually, you know, doctors, they usually would stop and they would do it, you know, it's part of who they are, right? So most of them would just do it. It's just kind of an instantly reaction. It's an instant reaction, right? I see somebody here, I'm gonna stop and see what I can do because I do have the training. Right? So, but yeah, I will look it up too, and then we can kind of clarify that. Anybody is 100% sure of that law or that instance? Yes.
I think it is a law. I took the emergency medical responder course, and she said that if there's an emergency or something that they have to stop, if there's nobody there, make sure somebody calls 911.
But again, what's it like? Because my question now is it a law or is it more like, again, your duty, kind of a moral duty towards your fellow citizens and that type of idea? If I'm making myself clear, I'm trying to figure out if it is just actually, if I don't stop, am I going to get legally in trouble? Or it's just going to be that moral hunting thing that, oh, I should have stopped and I could have stopped or I could have helped, kind of idea. Because there are two different things, right? Our own morals and then what the law mandates us to do. So anyway, we'll keep moving. All right. Then the last tool that you could use under the statutory law to mount a defense against negligence is the statute of limitation. And the statute of limitation is again a restriction on the length of time an injured party has in which to file the suit. So again, this is just kind of there is a certain period of time once the injury happened, kind of the clock starts running, and there is a set amount of time for that lawsuit to be filed. The statute for torts is usually 1 to 4 years from the date of the injury. And what that means is depending on the type of tort that you kind of are dealing with, it can be 1, 2, sometimes 3 years, again, up to 4 years, and you have that period of time to file the lawsuit. If that time expires, then you file the lawsuit, that will be a defense, right? It took you too long to file the lawsuit, pretty much. The statute